Moving on to section 5 of our rules. This is all about competence, legal malpractice, and other civil liability. Here, this subsection of the rules makes up 6 to 12% of your total MPRE exam. First and foremost, I want to cover the rule on competence. So here the rule states that a lawyer shall provide competent representation to a client. Competent representation requires the legal skill, knowledge, thoroughness, and preparation reasonably necessary for the representation. It goes on to state that in an emergency, a lawyer may give advice or assistance in a matter in which the lawyer does not have the skill ordinarily required, where referral to or consultation with or association with another attorney would be impracticable. Even so, however, assistance should be limited to that which is reasonably necessary in the circumstances. So to give you an example here, let's say that you are a corporate attorney and you have not stepped foot inside a courtroom for a criminal proceeding ever. Maybe you don't really have any experience outside of maybe law school and that limited experience in which you may have received. But let's say you receive an emergency phone call from a family member who unfortunately found themselves in some sort of criminal trouble. And you do not have time to say, ask a friend or to consult with another attorney, and you simply have to act. And you have to show up for, say, a hearing that's early the next morning. You can do this, even though you technically do not have, say, the competence or the skill that's required to represent this person in the criminal matter. You can show up to that hearing and represent them without violating these rules, so long as you do whatever is limited to getting through that hearing. In other words, do as little as possible that is required of you to move forward. That means that if you show up for, say, that hearing and you found out about it at the last minute and did not have time to, say, consult with someone or to find a different attorney, that is fine, but you should not continue to show up for the following court dates. You should make sure that another attorney is going to be replacing you that is competent to handle that matter. It's also good to know that lawyers can acquire competence in a field of law through study or by associating with a lawyer of established competence in that field of question. And in fact, that's how most attorneys learn. We learn from, say, other attorneys in our firms who, say, have more experience in trying to become qualified in that area of law. It also goes on to say that if a lawyer retains or contracts with other lawyers outside of their own firm to provide legal services to a client, the lawyer should first obtain informed consent from their client. And this makes sense because we are not supposed to be divulging confidential information about our clients' matters to other people. So if we are going to be reaching outside of our firm for help on a matter, say because we are not competent to handle it on our own, we need to first make sure we have permission from our client to do so. And then lastly, according to the ABA model rules here, it says that lawyers should keep up with changes in the law and must keep up with any continuing legal education requirements that are mandatory in their jurisdiction. The other rule that I would like to discuss here in this subsection is regarding the differences between having civil liability, say being sued for malpractice by, say, a client or a past client, and being disciplined, say, by your state bar association. So a civil case is going to be brought in a civil court, meaning you are literally being sued in court. You're going to be in front of a judge on that malpractice matter. Whereas if you are being disciplined, you are going to be in front of your local state bar disciplinary authority. So right then and there, that is your first difference. Additionally, if you're being sued for malpractice, you are being brought into court by the injured party, by, say, your ex-client themselves. Whereas if you are being disciplined for something that you did, the state bar is taking action against you, not the client. And then lastly, the outcome is different. If your client is suing you for malpractice, their hope is to win. And if they win, they want money. And that money is going to benefit them personally. If you're being disciplined by your state bar and say they disbar you or they suspend your license, your client is not receiving a monetary benefit as a result of your discipline. So again, that's the big differences between, say, being sued for malpractice civilly and being disciplined. Moving on to more of a discussion with malpractice. Remember that if, say, a person wants to sue you for malpractice, they are making a claim of negligence. This means they have to prove duty, breach, both types of causation, actual and proximate, and harm in order to be successful. So here to walk through this, when it comes to duty, this means that a lawyer owes a duty of care to act as a reasonably competent and diligent attorney would under similar circumstances. This duty is owed to a client or a potential client if the attorney did not make it clear that the attorney was not going to move forward and represent that person. Breach, what does this mean? This means that there was a duty, the attorney was supposed to act reasonably under the circumstances, and the attorney failed to actually do so, hence breach. It's also good to know, though, that an attorney is not going to be liable for mere errors in judgment, so long as that judgment was reasonable. Remember, us as attorneys, as professionals, we do not know how every single case is going to shake out. We do not know how a jury is going to decide or the type of decision that a judge is going to make. We could probably guess based on our experience and facts, but we can never know for certain. And that's really what that's getting at. An error in judgment, as long as it's a reasonable one, is not a breach. Moving on to causation, because again, remember, if someone is suing you for malpractice, they have to prove both actual and proximate cause. So the plaintiff must prove that the injury would not have happened but for the defendant's negligence, that is the actual causation, and that the injury was foreseeable. That is our proximate causation requirement. And then lastly, plaintiff must prove harm or damages to be successful in their malpractice claim. So the way that I want to end this is just to give you a final example. Let's say that someone hires you to take on a defamation case. They believe that someone has defamed them in some way. And they came to you, say, towards rather the last minute, and the statute of limitations is going to run soon. However, you go on vacation and you get busy and you fail to investigate and move forward on that client action. And you let the statute of limitations run and you never filed a lawsuit, and your client completely loses out on their ability to litigate that claim. So of course, they're probably going to sue you for malpractice because they feel like they were owed some sort of professional duty and that you breached that duty. You could also be disciplined by your local state bar for failing to prosecute that claim diligently, for forgetting about it, and letting your client think that you were handling it when you really weren't. Taking this a step further, if your client wants to sue you for malpractice, they have to prove duty, breach, both types of causation and harm. This means that they essentially have to prove that they would have been successful in their defamation claim had you actually prosecuted it accordingly. That's a pretty high burden for someone, a plaintiff, to prove that they would have been successful but for your breach of your duty. And they likely, absent having a really clear-cut case, might not win. Malpractice cases are challenging to win. However, even if your client isn't going to be successful in suing you for malpractice, you can still successfully be disciplined by the state bar for failing to timely file that lawsuit and for not being diligent on your client matter. So the whole takeaway from this example is that even if your client moves against you in a malpractice case and loses, you can still be disciplined. They are independent causes of action, so to speak. And it's very good to keep that in mind, as the NPRA likes to test to see if you know the difference between civil liability owed to clients and disciplinary action, as they are two independent, different causes of action. And that wraps up that subsection.